Good afternoon. Closing arguments in the trial of Mićo, Stanišić and Stojan Župljanin concluded last Friday. The prosecution has asked for the two accused to be sentenced to life imprisonment, whilst the defense asked for an acquittal. Župljanin's defense added that should the accused be found guilty, that he be given a sentence at the lowest end of the spectrum. A total of 147 witnesses testified, among whom 127 were called by the prosecution, 7 by Stanišić's defense, 10 by Župljanin's defense, and finally 3 were called by the chambers. During 353 trial days, more than 4,000 exhibits were admitted into evidence, 3,025 of them by the prosecution and 1,013 for both defense teams. Also in this case, the parties were this week ordered to file public redacted versions of their respective final trial briefs, including the annexes where applicable by the 12th of July, and all parties filed their final trial briefs confidentially on 14th of May this year. A housekeeping session will be held tomorrow in the trial of Jovica Stanišić and Franko Simatović at 9 a.m. in courtroom 2. Simatovic's last defense witness, former Serbian State Security Officer Radivoj Mićo, completed his testimony last Wednesday. His testimony was followed by a testimony of Radinko Novaković, who was prosecution's rebuttal witness. Novaković was also a member of the Serbian State Security Service during the relevant period covered by the indictment. Turning to the case of Radovan Karadžić, the accused will make his Rule 98 bis submissions on Monday, the 11th of June, starting at 9 a.m. in courtroom 1. The prosecution will respond to his submissions on Wednesday, the 13th of June, also at 9 a.m. in courtroom 1. According to the Rule 98 bis, the trial chamber can enter a judgment of acquittal on any count in the indictment by oral decision at the close of the prosecution case if there is no evidence capable of supporting the conviction. The prosecution case officially closed on 25th of May. The trial chamber in this case is currently on a 5-day site visit to locations relevant to the indictment in Srebrenica, Bosnia and Herzegovina and its surrounding areas. This visit, which began on Monday, is taking place under Rule 4 of the Tribunal's Rules of Procedure and Evidence, which sets out that the Chamber may exercise its functions at a place other than the seat of the Tribunal, if so authorized by the President, in the interests of justice. And the trial in the third contempt case of Vojislav Šešelj will be held on Tuesday, next week, 12th of June, immediately after the pre-trial conference, which will start at 9 a.m. in courtroom 1. Šešelj is accused of publishing 4 books he authored and 6 confidential filings, which all revealed confidential information on protected witnesses. And finally, a reminder that the Tribunal's President, Judge Theodore Meron, as well as the prosecutor, will address the United Nations Security Council tomorrow, 7th of June, at 10 a.m. New York time, which is 4 p.m. in The Hague, to provide an update on the work of the Tribunal and the progress made towards the completion of its mandate. The President's address will be immediately followed by that of the Tribunal's prosecutor. Press releases and copies of the President and prosecutor's speeches will be issued subsequently. Office of the Prosecutor.
One little comment: after the President's statement, there will be the ICTY President making a statement, and then you have the ICTY Prosecutor and ICTR Prosecutor. So
yes, in terms of ICTY, it's the President and then the Prosecutor.
Yeah. Nothing from my side. Yeah.
Any questions? No.
Maybe just a short one. Can you update us, Frederick, on the progress made on the order to the prosecutors in the Mladic case and the documentation they needed to supply to the defense in the case? How is that progressing?
Well, as far as the situation is concerned today, the first thing is that the trial, the presentation of evidence will start 25 June. The prosecutor has informed the chamber of what the mistakes that occurred, the reasons for that, and said that it would not be opposed to a reasonable delay of the start of the presentation of evidence. And in the end, then the chamber decided to start 25 June. The defense filed a motion, and we will indicating that there were still issues with the disclosure. We will soon respond to that and set out our position. So it will be, I think, in the next days that you will hear more from our side, and then the judges will decide on whether, on how to react to that.
Any other questions? No? Thank you.